California is known for its beautiful beaches, vibrant cities, and progressive policies. But a new debate is brewing in the Golden State, the legality of adults-only hotels. At the heart of the issue is the Unruh Civil Rights Act, a California law designed to prevent discrimination in places of public accommodation. This law clearly prohibits discrimination based on race, religion, gender, and other protected characteristics. However, it does not explicitly mention age as a protected characteristic. This ambiguity has created a legal grey area when it comes to businesses that cater exclusively to adults. The question is, does banning children from a hotel constitute age discrimination? Or is it simply a business decision aimed at catering to a specific clientele? The answer, unfortunately, is not so simple. The lack of clarity in the Unruh Act has led to conflicting interpretations and a great deal of uncertainty for both hoteliers and travelers. This debate is not just about legal technicalities, it touches on broader societal questions about the rights of businesses, the needs of families, and the boundaries of discrimination. It's a complex issue with no easy answers, and it's one that is likely to continue to spark debate and legal challenges in the years to come. As California grapples with this issue, it will be interesting to see how the law evolves, and whether the state will ultimately decide to explicitly prohibit or permit adults-only accommodations. The debate over adults-only hotels in California has been simmering for years, but it recently boiled over thanks to some high-profile developments. In February 2025, the Alila Morea Beach Resort in Encinitas, part of the Hyatt brand, announced its intention to become an adults-only property. This move came just weeks before the March 12, 2025 opening of the Whiskey Hotel in Hollywood, which also proudly promotes itself as an adults-only establishment. These developments have reignited the debate and prompted strong reactions from various stakeholders. Consumer advocacy groups such as consumerwatchdog.org, have been vocal in their opposition to adults-only hotels. They argue that banning children is a form of discrimination based on family status, which is prohibited under the Unruh Act. These groups are calling for the California Attorney General to take action against hotels that maintain adults-only policies. On the other side of the debate, the California Hotel and Lodging Association has issued cautious guidance to its members. While acknowledging that hotels can refuse accommodation with just cause, the CHHLA has warned that blanket policies against children are likely unlawful under the Unruh Act. Caught in the middle are the California Civil Rights Department and the Attorney General's Office, both of which have offered vague and non-committal responses to inquiries about the legality of adults-only hotels. This lack of clear direction from regulatory bodies has only added fuel to the fire, leaving both sides of the debate with ammunition to support their arguments. In the midst of this legal uncertainty, many California hotels have adopted a cautious approach to managing age restrictions. Rather than implementing outright bans on children, they have implemented policies aimed at minimizing the presence of young guests. Some hotels, for instance, have imposed age restrictions on certain amenities, such as pools, spas, or restaurants. This allows them to cater to an adult clientele while avoiding potential legal challenges. Others have implemented policies that limit the number of occupants per room, effectively making it difficult or impossible for families with children to book accommodations. These practices highlight the tightrope that hotels are walking as they try to balance the demands of a diverse customer base with the potential legal ramifications of their policies. The debate over adults-only hotels also raises interesting comparisons to age policies in other industries. For example, car rental companies in California are legally allowed to refuse service to drivers under the age of 25. This practice is rarely challenged, despite the fact that age is not an explicitly excluded category under the Unruh Act. Similarly, while Airbnb's platform policy prohibits age discrimination, individual hosts often find ways to discourage families with children from booking their properties. These parallels highlight the complexities of age-based policies and the challenges of balancing competing interests in a free market economy. The debate over adults-only hotels is far from over. With a growing market demand for child-free travel experiences, particularly for honeymoons, romantic getaways, and wellness retreats, it's likely that more hotels will explore adults-only policies. This growing demand is driven in part by a desire for peace, quiet, and relaxation, which can be hard to come by in hotels catering to families with young children. As the market evolves, it will be interesting to see how the law adapts. Court decisions on related issues, such as landlords refusing to rent to families with children, could have a significant impact on the adults-only hotel debate. If courts continue to uphold the broad interpretation of the Unruh Act, it could spell trouble for hotels seeking to exclude children. Ultimately, the question of whether or not adults-only hotels are legal in California may need to be settled by the legislature. A clear and unambiguous law that outlines the rights of businesses and the protections afforded to families would provide much-needed clarity and guidance. Until then, the debate is likely to continue, with each new development adding another chapter to this evolving story.